He has been paying 80% of the bills. There's been no contribution by the defendant for those bills for the home. She's basically working part-time by her own choice when she has old enough children that she could be working full-time. And the defendant and Aaron were both yelling at my client, yelling at neighbors, screaming that she wasn't leaving the house, and you can get the effing police to remove her if you need to.
Your Honor, when my client had to leave, she didn't have any lead time. She's been out of the house now for a couple of weeks.
I believe that the parties have agreed to joint legal and joint physical custody. What remains in question now is what the parenting time will be and what will happen with the exclusive use of the home order.
Mr. Velzen.
I don't recall that the attorney fees was that payment was going to wait until final resolution. I was under the impression that it would be like within 45 days.
Oh, I just recollect the court and chamber discussions indicating that it could be worked out with the finalization of the marital estate.
That was the intention of that, is that she wouldn't have to wait until then. That the attorney fees would be paid within 45 days, but then the calculations, if things needed to be reassessed or redistributed, that's what I'm trying to say, that it would be done in the final resolution, but that they should both have the same amount for retainers.
Understood.
And on the truck, I think the representation was that there's new management and that the policy has changed. So he's going to provide documentation of that.
Correct. And I may even have that now. My client's indicating that he has forwarded it to our office and as we speak.
Other than that, I agree that those were the agreements that we have reached.
Wonderful. All right. And then the the outstanding issue is exclusive use and the parenting time. Ms. Canfield-Kuiper, your client is the plaintiff, so I'll let you go first.
Thank you, Your Honor. With respect to the exclusive use order, it has been ordered by the court and been in place for a number of weeks now. That does include a provision that allows my client to give the defendant time in the home or to come to the home at his discretion and with his agreement. It is my understanding that he has done that on a couple of occasions, at least in the past several weeks, where he has been out of town or working late. And then he advises the defendant of that in advance, that she's welcome to come to the home and spend time with the children or to help assist getting the house ready for sale. And that thus far, that has not been problematic because there's very little communication and contact between the two of them. There was a concern on one occasion that she left for work rather abruptly, and the area in which she had remained was untidy, and there was a showing that day and the defendant had to clean it up. But my understanding is for the most part, she does take care of that if and when she's been there. My client's position is that he is, of course, the major breadwinner for the family. He has been paying 80% of the bills. There's been no contribution by the defendant for those bills for the home. He has resided there with the children, and it's what they are used to since the order was put into place. And he also has maintenance of the pool on almost a daily basis, as well as the lawn, in order to make the house most appropriate and looking good for the realty market. So he would ask that the court leave that order in place. Of course, it still contains the provision that he can allow the defendant there when he's not, or to assist with preparation for viewing or open house for the home. But he just does not believe at this point is in the children's best interest, or actually their marital estate best interest, to have to leave the home every other week so that nobody's taking care of the pool and the lawn when he's not there. And also, he's reticent to have to find a place to stay when he is actually paying the entirety of the expenses for the marital home. It's my understanding also, he's been informed that the defendant did leave the job. And I won't go into great detail about that, but she's basically working part-time by her own choice when she has old enough children that she could be working full-time. So that goes into play with respect to these payments that my client is making towards the home with no contribution from the defendant. So we would respectfully ask that the court leave the exclusive use of the home order in place. Now, with respect to parenting time, it's my understanding that they have been able to work on that as they agree. There haven't been any huge issues in that regard. They are co-parenting well for the most part. But during some exchanges or drop-offs to the home by the defendant of the children, there have been words exchanged and yelled at my client, either in the presence of, or at least while the children were home and inside the house, where she was yelling at him and calling him a liar and various other things in their presence, which was part of the reason we instituted and requested this order in the first place. So I know when it was served on the defendant that there was another person present by the name of Aaron Hiskey. And the defendant and Aaron were both yelling at my client, yelling at neighbors, screaming that she wasn't leaving the house and you can get the effing police to remove her if you need to, type of thing. And of course, with the children being home, that's certainly not appropriate conduct. So in the event that anything would be ordered to modify the ex parte exclusive use, we would most respectfully ask that Aaron Hiskey be prohibited on a no trespass order from being at the premises during either party's parenting time, should that change and the exclusive use order be modified. I think that my client's position is the parenting time as they agree is worked out well and should not be changed.
Mr. Paulson.
Thank you. It's our position, strong position, that the ex parte order was based on fabrication and not fact. These people have had their share of problems. They're getting divorced. When they were together, she basically lived upstairs, he lived downstairs. But all that is in a sense irrelevant, because if it's a nesting arrangement, they won't see each other. She can take care of the pool. She can take care of the yard as well as he can. They need to have the house ready to be shown. Apparently there have been about 5 times when people wanted to see the house that he was not available and had to cancel the showing. That's not a way to sell a house. But it comes back to basic fairness. He says he's going to have a hard time finding a place to live. Well, he at least has some lead time. She had 10 minutes because she got an order and then had to get out of the house. So we strongly recommend that we go to a nesting arrangement. This is a temporary situation. The house is going to be sold, and a nesting situation where one party leaves at about 5 p.m. or by 5 p.m. on Sunday, and the other party comes in no sooner than 6 p.m. On that Sunday. And they'll just rotate. They'll both have an obligation to keep things clean, keep it ready for showing. We can get the house sold and we can get these people on their way. Thank you.
All right, thank you. I told counsel when I was meeting with them in chambers, I'm not a big fan of nesting arrangements in general. However, I do believe in this situation that it is in the best interest of the children. The opposition or the concerns I heard about the nesting arrangements and what I've read in the briefs have to do with the contact between the parents. This is a short-term situation. It sounds like both parties are motivated to get this house sold. Frankly, they both need to so that they can move on with their separate lives financially. So the hope is that this house would sell soon, and so that whatever arrangement the court orders at this point is a very short-term situation. And I do believe it's in the best interest of the children that there be a nesting arrangement, that the parties alternate week on, week off, that the party to begin their parenting time has to leave before 5 p.m. on Sunday, that the other party may not enter the home or be at the home at any time prior to 6 p.m. on Sunday, and then just do that every other week. The party whose week it is responsible for the upkeep of the home, including the pool and the lawn maintenance. And that may require that Ms. McBriar hire someone to do that for her weeks. Again, this is a very short-term situation. Since Mr. McBriar is paying the lion's share of the bills at the moment, and as he should be because of the differential in the parties' incomes at this point. I believe that the lawn care and the pool care would not exceed 20% of the party's total marital income, and that would be a reasonable amount for Ms. McBriar to contribute in order to keep the home at the level that it needs to be for showing, particularly with a pool. I do believe that based on what I've heard, that Aaron Hiskey should be prohibited from being at the home. Again, this is a short-term situation and is limited strictly to this time prior to the house selling. Is there anything else I need to address?
I don't think so, Your Honor.
I guess I would ask that the court give my client at least a week to 10 days to find a place to go. He's not discussed that with anyone because he has been under the exclusive use order, the resident of the home. So if the defendant's week could begin August 18th, that gives him at least this coming week then would be my client's. And then it gives him time to find a place to go for the weeks that he would have to be out of the home.
Your Honor, when my client had to leave, she didn't have any lead time. She's been out of the house now for a couple of weeks. He's got till Sunday. I think this arrangement ought to start in 2 days.
I will give him until the 18th. And just reiterate that the whole point of this is that the two of you not have any contact. If for whatever reason one of you is there when you shouldn't be, the other one needs to leave and contact your attorney, right? But no contact between the two of you. That's not an emergency, right? And is there anything further?
Not that I can think of, Your Honor. Who would you like to prepare first the stipulation and then the modification of the exclusive use?
Mr. Velson?
I can prepare the paperwork.
Wonderful. And if you would provide that to the court electronically, that would be appreciated because then I can sign it and get it back to you quickly.
Will do.
Thank you, Your Honor.
Thank you.
Thank you.
Great. I did see a chat from Mr. McBriar. Anything the two of you agree to, as always, is fine. So if you agree to something different than what the court order is, as long as it's in agreement through your counsel, that's fine. Okay. All right. Is there anything further?
No.
All right. We're adjourned. Thank you.
She hasn't received a dime of her money. He now owes her $108,000.
I haven't seen the kids in 3 years. Why is she doing this at this time?
She's already owed that $108,000. Mr. Sowers is buying time so that he can get more money. I don't care, with all due respect,